Hi, Miss Bridgewater.
Hey, how's everybody today?
We're good. We're good. We're good, I guess. How are you?
I'm great. Judge, for the benefit of the SAP calendar, if they're being reset to the SAP calendar, it's going to be February the 15th.
Okay. Day after Super Bowl, Valentine's, and then 15th. Got it.
Absolutely. So guess what? We may have quite a few cases then.
I know, right? A lot going on that weekend. Let's see, where are my ASGs?
We're here, Your Honor.
Good morning. Good afternoon. How are you?
I'm fine. How are you?
Good. Who else is with you? Okay, Miss Duncan.
I'm here, Your Honor. Good afternoon.
Good afternoon. How are you?
I'm well.
Okay, and Miss Guidry. And then I have Miss Kim and Miss Gant, correct?
Yes, Your Honor.
Good
Good.
afternoon, Your Honor.
Good afternoon.
Good afternoon. Your Honor, I need to have a little bit of time with one of the clients, position 7. His
Okay.
name is Cashmore. If court allows, I would love to have a little bit of a breakout room time with him.
Okay. You mean with just the client?
Yes,
Okay.
Ms. Kim, he was in felony court. I was just waiting for them to bring him over.
mhm.
I'll put him on the phone with you as soon as we get him.
Okay, thank you very, very much.
All right. Is everyone ready to begin?
Yes.
If you're ready, Your Honor, this is position number 9, Ms. Julia Edmonds.
All right. I'll do my opening and then we'll go to number 9. Ladies and gentlemen, good afternoon. My name is Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has accused the cases of the offenses brought against them. And the case has been bound over to the State Court of Fulton County. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we're going to address several matters, including bond, possible arraignment, or a consideration of a possible plea offer if one has been made by the state at this juncture. Again, we'll be providing you with a reset date for arraignment. If it is not held today, that SAP calendar date is February the 15th. I'm going to begin and advise everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. I want to also let the persons on this calendar know that you have a constitutional right to remain silent. And remember that anything that you say about the facts or occurrences and circumstances regarding your case can and will be used against you. So please defer to your attorney, listen to them, and let them guide you in that manner and represent you as they are qualified to do. Also, you do have a right to an attorney, which you will see on the screen. And if you have private counsel, I will note that as well, and they should be on here too. The first case that we have, again, is position number 9, and that's Julianne Edmonds. Is that who we have, Deputy?
Yes, that's correct.
Okay. All right, this is case number 22CR000480J. And Ms. Edmonds, you're charged with 1 count of driving improper erratic lane change Second charge of driving, possession of open alcohol container. Third charge, DUI, less safe. And fourth charge of willful obstruction of law enforcement officer, all with the offense date of February the 1st, 2022. Do you have anything pretrial?
First arrest.
All right, for the state. Whose case is this?
This is Miss Duncan's case.
I'm sorry?
It's Miss Duncan's case.
Okay. Oh, there she goes.
My
All right.
apologies, Your Honor. What's the position number? I didn't hear you.
Position number 9, Ms. Edmonds.
One moment.
Okay.
Yes. We get to the right page. This incident occurred yesterday on Howes Road. The bond on this case is currently set at $10,000 surety. That's $2,500 per count. The state is going to ask that bond remain as set. In this case, Your Honor, there was a single car collision into a ditch. Upon encountering officers, the defendant in this case did not even know that the accident had happened. 2 empty alcoholic beverage bottles were found in the passenger side of the vehicle that the defendant was driving. The defendant told officers at that time that she had taken prescription medication earlier, in addition to the open alcoholic beverages in the vehicle. The defendant told officers and EMS things like get the F off of her and began pulling away when they attempted to detain. And the defendant in this case admitted to being drunk, attempted to walk away from officers again on several occasions, and was very unstable on her feet. Officers had to grab her arms to keep her from falling down. And according to the warrant, this defendant was going in and out of consciousness once being placed in the patrol car. It is due to the severity and nature of this offense and the danger that this defendant is to herself and to others on the road that we request a bond remain as set at $10,000 surety, $2,500 per count, no driving, and no alcohol, drugs, or weapons.
Your Honor, Miss Julia is 22 years old. As pretrial said, she has no criminal history whatsoever. This is first arrest, one first mistake, and then we would like to ask for signature bond because he meets all the criteria for signature bond. And currently he has been here in Georgia for 14 years. And he is 22 years old, going to Georgia State University, studying accounting major. And he also works as a public cashier at Publix to support herself as well. And she has parents, brother, sister here in Georgia. And we request that you will allow her to have signature bond, Your Honor.
Okay. I'm going to continue the $10,000 surety bond, $2,500 on each count. No drugs, alcohol, or weapons. If Ms. Edmonds makes bond, and obviously I'm sure her license are suspended, and no driving except for medical care to see her attorney, possibly for work, but she would have to get that from DDS. So I'm going to have the bond to remain as it is.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Next, we'll have position 5, Bowles.
Okay, you're Simone Bowles.
Yes.
Okay, this is case number 22 CR 0000473C. You're charged with one count of criminal trespass with the offense date of February the 1st, 2022. Do you have anything pretrial?
This is second adult arrest, 2019 trespass conviction. The simple battery with that was dismissed. He had a arrest out of Florida. It was juvie, but they gave him 88 years probation according to this GCIC for possession of 20 grams or less of cannabis. So that's all I have.
All right. Ms. Duncan?
Your Honor, this incident took place yesterday at 3350 Mount Gilead Road. And in this incident, however, it's a criminal trespass, but the circumstances surrounding this incident were that the victim in this case, Sierra Upshaw, Cierra Upshaw, common spelling, returned back to the scene of her properties, which are apartments 92 and 93 at that location. And upon returning, she noticed that her units had noticeable bullet holes. So she contacted police. Police were able to track where the bullet holes came from by going door to door. They ended at unit 91 and they encountered the defendant in this case. The defendant stated to police that he was teaching his girlfriend how to load a handgun inside the apartment, and the gun discharged one round into unit 92. However, officers located 2 shell casings in front of that apartment and a projectile in apartment 93. Due to the serious nature of this offense and the fact that it involves a handgun, the state would request, reckless use of a handgun, the state would request a bond of $5,000 surety, no further contact with the victim in this case, to stay away from the victim's units, and no alcohol, drugs, weapons, or firearms.
Your Honor, we do not oppose any of those bond conditions except $5,000. Surety bond is a little bit too high for 20 years old. Mr. Bowles is only 20 years old. And he has been here from June 2021. He's been here. And before he lived in Florida, he used to live here in Georgia as well. He also has a job at Fox Brother Restaurant as a chef. He came here because of the job, and he wanted to go to college at Georgia Piedmont Technical College. He was studying there. That's why he came to Georgia. And because of a pandemic and COVID, he was not able to do a lot of studying, and he had to make some money. And he's going back to school this spring, and he wants to continue studying the criminal justice that he wants to pursue. And he has no biological child. However, even though he's a single, he has 3 stepkids that he is actually helping and to support. So considering the fact that his age is very young and also he is hardworking student, I would like to request for bond maximum of $400, Your Honor.
Okay. I'm going to issue the bond for $5,000 surety bond. No drugs, alcohol, or weapons while on bond. I'm going to order the stay away from 3350 Mount Gilead Road, apartments 92 and 93. I'm going to order that there be no further contact with the victim, Sierra Upshaw. And I think that's all I have to take up. Is there anything else?
I want to clarify that he's not allowed to go back to apartment 92 and 93, but he can go back to apartment J91. Am I correct, Your Honor?
The close proximity to the other two alarms me, I'm assuming. If he makes bond, the problem may be running into the victim. And I am concerned about the charges of firing a handgun that may have gone through several units since shell casings were found. I guess that, with this, we would have to just make sure again that he has no contact with the victim coming and going. And if he were to return and see Miss Upshaw rather, that go the other way and stay away from her and those two units.
Thank you. Thank you, Your Honor.
Okay.
Thank you, Your Honor.
All right, you're welcome.
Next, we'll have position 10, Mr. Freeman. Ms. Kim, you can call the courtroom. Do you have the contact number?
May I please have one more time?
It's 404
Sure.
612 2392.
Thank you.
You're welcome. You can call now.
All right, this is case number 22 CR 000484D. Ronald Freeman. And you are charged with 1 count of cruelty to children in the 3rd degree, 1 count of battery, family violence, and a 2nd count of cruelty to children in the 3rd degree, with the offense date of February the 1st, 2022. Do you have anything pretrial?
The second arrest, last was 2017, ag assault, possession of a knife or a firearm during the commission. He's on first offender probation for that in Clayton County. In 2018, they gave him 7 years probation.
Okay. All right, Ms. Guidry.
Yes, Your Honor. So yesterday, officers arrived at 215 Crusader Place in Fairburn. They spoke with Miss Starnisha, that's STARNISHA Perkins, common spelling, who stated that her and the defendant got into a verbal altercation about her getting a new phone. The defendant told her to come upstairs so that they could talk. And when she entered, the defendant accused her of cheating, started to hit her with his fist, and threw her against the room. Ms. Perkins ripped the defendant's shirt and scratched him in an attempt to get the defendant off of her. The parties do share 2 children who were present at this time, Your Honor. The victim sustained visible bruising to her chest and neck area, and the defendant had scratches on his neck and arm. I would like to note that the parties are ex-spouses and that they do live in the same residence together, but they live in separate rooms. Your Honor, we're asking for a $7,000 surety bond, a stay away from 215 Crusader, no further contact with Ms. Starnisha Perkins, 1-day anger awareness, 3rd-party contact with the children, and no alcohol, drugs, or weapons. Your Honor, the reason for our recommendation is due to his criminal history. 1, because he does have an aggravated assault charge, which he is on probation for, and the seriousness of the crime due to him committing this act in the front of his 5- and 6-year-old children, Your Honor. Due to that nature and the nature of the crime, Your Honor, that's the reason for our recommendation.
All right, Ms. Gant.
All right, thank you, Your Honor. Mr. Ronald Freeman is 30 years old. He was born in Oklahoma City, but he has been in the Atlanta area for the past 10 years. He has community ties here, including his children. He is the proud father of 2 sons, ages 5 and 6. He also has parents and siblings in the Atlanta area. Your Honor, at this time, we are opposed to the stay away order. Mr. Freeman has informed me that that is his residence. His name is on the mortgage, his name alone, and that he and Ms. Perkins were never married. They basically were engaged at one point, but then the relationship broke down. He also informed me that Ms. Startisha Perkins has vacated the property and that she is living with one of her, vacated the property and is now living with one of her relatives with their 2 children. Mr. Freeman has served in the military. He was honorably discharged. He served for 18 years. He has completed 72 college credits in the area of business administration at Georgia State University. He also plans to continue pursuing his degree. He is gainfully employed as a Coca-Cola truck driver, and he informs me that he is the sole breadwinner, and he states that the mother of his children, Ms. Perkins, with whom he shares the 2 children, has not worked in over 7 years. So he is responsible for paying the mortgage and providing for all needs of the children. Now, turning to the allegations, Mr. Freeman denies the allegations. He states that he did inform the police that he began asking Ms. Perkins questions, definitely not about cheating, as this couple is no longer together. In fact, as we heard from the state, they sleep in separate bedrooms. He states that Ms. Perkins attacked him first, and he was merely acting in self-defense. And he states that the scratch that she has on her neck was due to a broken nail. So he believes that while she's flailing her arms, she inadvertently scratched herself. And I would also just remind the court that my client did in fact have bruises, visible bruises on his chest and his neck. I acknowledge my client's history, that aggravated assault while within that 10-year period. I think it bears noting that he states that he actually was convicted of this charge, and some of the facts were that he was actually defending Ms. Perkins because she was attacked and he was acting in defense of her. Now, given the reasons that I've stated, I am requesting, Your Honor, a signature bond for Mr. Freeman. And if Your Honor is not inclined to grant a signature bond, then Your Honor, I would ask for a bond of no more than $1,500, and that would be $500 for each charge. Again, we are opposed to the stay away, as that is his residence. We are unopposed to the no further contact orders along with third-party transfer. Thank you.
Your Honor, just briefly, we'd still ask for that stay away and no further contact due to this incident just happening yesterday. And we have no information whether or not she has left the home. So just to be safe for our victim, we want that stay away and no further contact.
Okay.
Well, Your Honor, if we are able to, and I do apologize for interrupting, but if we can modify that such that if Ms. Perkins is no longer in the residence, then the stay away doesn't apply.
Okay, what I'm going to do with the bond is to order a surety bond in the amount of $5,000. The first charge, $1,500. Second charge, the battery of $2,000, and then the third charge, the other cruelty of $1,500. That should be $5,000. And what I'll do is order that the no further contact with the victim, Starnisha Perkins, and I'm going to order the stay away from the Crusader Place. I think it's 215 Crusader Place. As long as Miss Perkins is there. If the defendant makes bond and goes there and she is still there, he cannot reside there until she no longer does. So he needs to find another place to live as long as she and the children are residing there, even though, you know, his name may be on the mortgage. I want to make sure that she and the children are safe and have somewhere to go. If there's going to be visitation, that it should be arranged by a third party. No drugs, alcohol, or weapons while on bond. And I think that should do it, unless there's anything else that either side wants to take up.
Nothing further, Your Honor.
Okay,
Nothing further from the defense. Thank you.
okay.
Next, we have position 11, Mr. Maiden. Is that you?
Okay, are you Raheem Maiden? Or Maiden?
Mask up.
Not for sure. I don't mean to mispronounce your last name. This is case number 22 CR 0000475H. You're charged with one count of certain acts, business rail station prohibited, and a second count of criminal trespass with the offense date of February the 1st, 2022. Do you have anything pre-trial?
16 total. History out of Colorado and Mississippi. I'm gonna start with Colorado first. 2011 shoplifting conviction. 2012 shoplifting arrest. As far as Mississippi, June 2021, possession of a controlled substance. Disturbing the peace, it just shows as an arrest. You got a probation hold out of DeKalb County. FTA warrant out of Gainesville. Last arrest in Georgia was back in December in DeKalb County, probation violation. He's on probation in DeKalb for burglary. He's on probation in Fulton for burglary as well. What else? There's 2 burglaries. 2015 burglary arrest. Another 2015 burglary arrest. 2014 probation violation. 2014 failure to appear, theft by taking, theft of services, giving false name. That's all.
Okay. All right, Ms. Duncan.
Your Honor, this offense occurred yesterday at the Hamilton E. Holmes train station at 70 Hamilton E. Holmes Drive. The defendant, well, there is a current bond set at $3,000 surety. That's $1,500 per charge. The state is going to be asking that that bond remain as set. In this instance, the defendant was yelling and cursing loudly at MARTA officials on the platform. He was told to calm down on several occasions, refused to do so. At that time, MARTA officials charged the defendant with a code of conduct violation, and the defendant was asked to leave the station and refused to leave the station at that time. The state is particularly concerned because of the risk of reoffense. He's had similar behavior like this in the past, giving the disturbing the peace, and we're concerned about the ties to the community. He has arrests out of Mississippi as from 2021, and we're concerned that this defendant may be a flight risk due to the FTAs that pretrial has listed. In addition to the $3,000 surety bond we're also requesting a stay away from the Hamilton E. Holmes train station and no alcohol, drugs, or weapons.
All right, Ms. Gant.
Thank you, Your Honor. Mr. Raheem Maiden is 29 years old. He has been in the Atlanta area since age 8. Therefore, he has community ties. He has family here, including siblings and also aunts, uncles. So, Your Honor, he has community ties. At this time, Your Honor, we are opposed to the stay away from the H.E. Holmes MARTA. Your Honor, Mr. Maiden does not have transportation at this time. He relies heavily upon the trains to go to and from work. He has completed 1 year of college in the area of marketing. He is now employed at Checkers, but he has only been in that position for 6 months. Prior to that, he was unemployed for a long period of time. Therefore, he is unable to make any bond. He's unable to make any bond at this time, Your Honor. Turning to the allegations, Mr. Maiden denies the allegations. He states that no one was in the train station and that he cooperated and that he he cooperated and complied with the officer's request for him to leave the property. He was complying with the officer's complaint. I am tongue-tied. I do apologize. He complied with instructions that were given, and he denied using any loud or profane language. Now, regarding my client's history, we stand by our position that he is not at a risk of reoffending. We heard from pretrial that his history primarily centers around theft, that disorderly conduct. There is, according to what I heard, there is no disposition on that. Furthermore, Your Honor, again, he did not offer any violence. There are no allegations of any fare evasion whatsoever. Regarding his issues with probation, Your Honor, he informed me that many of his issues with probation were because he was unable to go to those appointments because of his difficulties with transportation. And we do understand totally that it is ultimately his responsibility to get back and forth. And again, Your Honor, that's why I am opposed to the stay away for the Holmes MARTA, and would instead that you continue to allow him to use the MARTA as he is presumed innocent. Finally, Your Honor, let's see here. Again, we do see that he has an agency hold. Therefore, Your Honor, I am requesting that signature bond so that he may be released to deal with the agency holds. And he has advised me that the agency hold out of Gainesville is for a speeding ticket. And for these reasons, Your Honor, I'm requesting a signature bond, or in the alternative, a very low bond. Thank you.
Okay. All right, I'm going to order a surety bond in the amount of $3,000, $1,500 on each of the charges. I'm going to order that there be no drugs, alcohol, or weapons while on bond. I'm going to order a stay away from the Hamilton E. Holmes MARTA station, not to go back there. And I guess that will be it. I was thinking of something else, but no, that will be all that we have unless there's anything else that either side wants to take up.
And Your Honor, just for clarification, it is just for the Hamilton E. Holmes. He is able to still use MARTA, but not stop at that station. Is that correct, Your Honor? That
is possible. Usually MARTA goes ahead and does a ban, or go ahead. They usually go ahead and order them to not be on MARTA at all. I don't know if he has that or not. Once he was given the trespass violation, usually I do. Maybe he can take the bus if he can act appropriately, and not the trains, but I don't know if he's going to be able to logistically avoid that station. So, Mr. Maydon, you must avoid that station and not go back to that one. But I'm not sure, and I guess you can check if you are able to make bond to find out if you're banned from all MARTA stations. Just a little conflicted on whether that would be the case, but right now we certainly do not want you going back to Hamilton E. Holmes. Okay?
Yes, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Let me go back to, I'm sorry.
Position 1, Mr. Alexander.
All right, let me go back to position 10 on Mr. Freeman. And Ms. Bridgewater, help me with this. I need to also order and add that if Mr. Freeman returns to the location and the victim.
I'm sorry, Judge Mincy, he's already out of the courtroom.
Okay.
But I did put on there, he's not to go if the victim is present.
Okay, I was going to give him a one-time escort to get his personal belongings, but we'll just deal with that differently.
Order if you would like me to.
Okay. Just making sure if that needed to be given to him, Ms. Duncan and Ms. Gant. All right, we'll go on to position 1. Are you Mr. Anthony Alexander?
Yes.
Okay, this is case number 22 CR 000471G. You're charged with 1 count of abandonment of a dependent child. The offense date is September the 29th, 2021. Do you have anything pretrial?
He has 4 total. He don't have anything related to this charge. Do you still want history, or you just want what's related to this charge?
It's only 4 total.
Yes.
Is it something that you don't want to mention?
I mean, he has that, but it has.
Are there any convictions? Okay. All right, does he have a purge amount?
He's talking, but he's muted.
Oh.
Man, I'm just talking. Yeah. So he has 4 total.
Okay,
He don't have anything related to this. I sent you that in the chat.
okay,
No, he don't have any convictions.
okay.
Okay.
And does he have a purge amount or anything?
$752. What's on the booking?
Okay,
Yes.
752. Okay,
Yes, we have to. And we just ask that he pay that purge amount, and then once he pay it, he'll be released.
okay. All right,
Your Honor, I would like to ask for reduction of the purge amount because he has been unemployed. First of all, he completely denies allegation. He does not want to abandon his children at all.
well, hold on 1 second. Let me let the state go first. Is there anything?
I'm sorry.
Yep, is there anything else
I
that
thought you
the
were
state
done.
wants to add? That's okay. But I cannot,
Well,
I cannot amend that purge for child support. But go ahead, Ms. Guidry.
Right, Your Honor, and I was going to say that child support is very serious, and we take that very seriously. This involves 3 children, and $752, Your Honor, is a minimum he can give to his children. So I believe that is an appropriate amount to give to his 3 children, and he should have to pay that purge amount to release himself.
Okay. All right, go ahead, Ms. Kim.
Well, he has been going through a difficult time with pandemic. Before pandemic, he was actually cleaning the cars and he provided detailing services. He worked at Chevy about 2 to 3 years. And after COVID hit, not that many people wanted to have somebody else to clean their cars. He was losing a lot of business and he was not able to make so much money. So that's why he could not make payment for the child support. He has 4 children. So total is about $1,000 a month. And he is currently willing to he can do $300. He's going to borrow from his father and brother. And yet he's still there because he could not afford $752. That's it, Your Honor.
Okay, I do not have the authority to amend the purge, and usually with child support services, they will have to get a Superior Court judge to revisit the purge. And then, of course, once he pays the purge, then this case is dismissed. But I do not have the authority as a state court judge to amend the purge for a Superior Court case. So he'll have to get that before, it looks like Judge Manning, I believe, to revisit the purge amount.
Yes, Your Honor.
All right, so that will stay at the $752 purge.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Next, we have position 2, Mr. Anderson.
All right,
Anderson.
All right, are you DeAndre Anderson?
Yes, ma'am.
All right, this is case number 22 CR 000472C. And you're charged with one count of theft by receiving stolen property and a second count of possession and use of drug-related objects. The offense date is February the 1st, 2022. Pretrial, do you have anything?
14 total. Last arrest was May 2021. Ag assault strangulation. He has an open case in the Superior Court, 22 SC 180252. It's ag assault, battery, and theft by taking. I counted about 6 probation violations in the history. July 2020, obstruction, simple battery, family violence. 2020, probation violation, battery DV. Failure to appear for criminal attempt to commit burglary, criminal damage to property, second degree, possession of tools. 2019 trespass conviction. It was amended from criminal damage to property. 2015 battery, family violence, second or subsequent offense, reckless conduct, fleeing an officer, obstruction, driving without a valid license. It just says transferred. You got the 2012 probation violation, 2010, 2002. That's it.
Okay. All right, Ms. Guidry?
Yes, Your Honor. So yesterday, officers arrived at 2784 Metropolitan Parkway, Atlanta. That is Allen Auto Repair. They spoke with Shakai, SHAIKH, last name ALAMGIR, who stated that he saw the defendant walking down the street with his car jack. He approached the defendant and the defendant apologized for taking the car jack and stated that he received the item from someone else and he knew that it was stolen. The defendant informed the police that he did not know the individual who gave him the jack. He was arrested, and upon search of his person, officers found a glass pipe commonly used for smoking crack cocaine in his front right pocket. Your Honor, we're asking for a $5,000 surety bond, $2,500 on each count. No further contact with Shakai, last name ALAMGIR, a stay away from Allen Auto Repair, and no alcohol, drugs, or weapons. Your Honor, this is largely due to his criminal history, given that he has an open aggravated assault, battery, and theft by taking, and also another open simple battery, family violence, and a willful obstruction. And Your Honor, he is a flight risk, given that he just was arrested in 2020 for a failure to appear, and he had 3 counts of failure to appear in 2020 as well. And that's the reason for our recommendation.
Okay.
Mr. Anderson is 37 years old and he lives with his mother. And actually, the location where the incident occurred is where he works. He works as an auto mechanic. He has been doing that for about 10 years. He denies all the allegations. His education level is up to 11th grade. He couldn't finish. He has 1 child right now with his girlfriend, and he has to take care of the child as well, be able to provide. He has a driver's license, and we request that the bond amount will be lowered. I know it's gonna be hard, but I want to ask for a signature bond. If that is not permissible, $2,500 surety bond. Thank you, Your Honor.
Okay. All right, I am going to order a $3,500 surety bond with the first charge, theft by receiving stolen property, $2,500, and $1,000 on the possession of the drug-related objects for a total of $3,500 surety bond, and a stay away from the 2784 Metropolitan Parkway, the Allen Auto Repair. Now, that's not the location where Mr. Anderson works, is that correct?
It is the location that he's working, actually.
It is the location.
Yeah, he's afraid that he's gonna get fired. But That's where he works, Your Honor.
And that's the location where the incident occurred, correct, Ms. Guidry?
Yes, Your Honor, that's the incident location.
Okay. That's a little sticky there. Well, he probably is not, probably already fired if they caught him with something that was alleged to be stolen, this carjack. I'm gonna order him to stay away from there unless he still has his job. And I guess if he gets out on bond, he'll have to talk to the owner to find out if he's still allowed to work there. No further violent contact with the victim. And the only reason he can be there is if the victim or whomever chooses for him to still work there. No drugs, alcohol, or weapons while on bond. Is there anything else that I need to take up?
No, Your Honor.
That's all, Your Honor.
All right, thank you. We have the interpreter on the Zoom,
For which case, Judge?
and that's what I'm trying to find out.
Your Honor, we are not in need of an interpreter today, and I do not believe that one was requested.
Okay. And I just see a note in the chat.
No, ma'am, we don't have an interpreter on for today, Judge.
Okay, just making sure. If so, I was going to say that they were not needed today. Okay. All right, thank you. All right, who do we have next?
Petition 3, Andre.
Okay, are you Christopher? Is it Andrade?
Andrade, Christopher Andrade.
Andrade, okay. This is case number 22 CR 000-482E. You're charged with 1 count of willful obstruction of a law enforcement officer and a 2nd count of disrupting public school. Offense date is February the 1st, 2022. Pre-trial, do you have anything?
13 total. 2019 trespass conviction out of Cobb County. 2019 driving without a valid license, NOLO. 2017 probation violation out of Bartow County. 2016 failure to appear Bartow County, that was dismissed. 2 counts felony obstruction conviction. 2015 out of Cartersville, Bartow County. 2015 driving without a valid license. 2015 probation violation, 2014 probation violation. And 2011 failure to appear for fleeing an officer, theft by receiving auto. Disposition for those was not prosecuted. That's all.
Okay. Ms. Guidry?
Yes, Your Honor. So yesterday, officers responded to Sylvan Hills Middle School, which is located at 1461 Sylvan Road, Southwest Atlanta. They were called due to an irate male. Upon entering the office of the school, the officer noticed that the defendant, who was at the school to pick up his brother, was using profane language toward the staff and was extremely irate due to the staff not assisting him because he would not put on a mask. He was asked to go outside after still being very irate, and the officer asked him to leave the premises. The defendant told the officer he was not leaving. He was going to sit in his car and wait for his brother and wait until someone brought him his brother. Because of the defendant's level of irateness, the officer tried to stop the defendant from getting into his car because he didn't know what the defendant had within the vehicle. After attempting to stop the defendant, the officer grabbed the defendant to place him under arrest. The defendant snatched his wrist away and raised his hands toward his face and positioned himself in a fighting stance. A struggle ensued, and after more officers arrived, they were finally able to handcuff him. Because of the defendant's actions, the school had to be placed on lockdown while this incident took place. Your Honor, he currently has a $4,000 surety bond, $2,000 on each count. We're asking that you maintain that bond. You issue a stay away from 1461 Sylvan Road Southwest and no alcohol, drugs, or weapons. This is largely due to the defendant's conduct in this case, Your Honor, putting the school, his brother, and the other kids at risk, and because of his failure to appear is making him a flight risk. He has 4 within the past, Your Honor. Given those reasons, that's why we're asking for such a recommendation.
All right, Ms. Kim?
Your Honor, Mr. Christopher is actually 28 years old. He is kind of like a father of the family household. He is the eldest among 6 siblings. Most of his siblings are 14 years old and under. So he has been working to support them financially. Actually, he graduated from high school, and after that, he had to work. He sacrificed his dream to have different education, higher education. He chose to work at construction sites so he can make money to provide for younger siblings. And he has a girlfriend here. He also has a daughter who is 5 years old. He's been here for like 28 years. That's why I believe he's not a flight risk. He wants to stay here with his family and his daughter. He's a single father as well. And he does not drive, and he doesn't have a driver's license. So he's been taking Uber, and he's okay to stay away from that incident location, 1461. However, due to the fact that he has a lot of responsibility to take care of his siblings, younger siblings who are minors, we would like to ask for $520 bond, Your Honor.
All right, I'm going to order that the bond be set at $4,000, $2,000 on each charge. I'm going to order stay away from Sylvan Hills Middle School. If you have to pick up your sibling, you're going to have someone else to do that. Right now, that you'll be under a stay away while on bond. And I'm going to order that you have no further violent contact with any of the employees at the school. I'm going to order no drugs, alcohol, or weapons while on bond.
Your Honor, is that a surety bond?
Yes, $4,000 surety bond. $2,000 on each charge.
Okay.
And I'm sorry, you're going to have to stay away from the school while you're on bond, and have someone else to pick up your sibling, and no further violent contact with the employees at the school, at the Sylvan Middle School.
Yes, ma'am.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Next, we have position 4, Mr. Austin.
All right, you're Mr. Milton Austin.
Ma'am. Yes, ma'am.
Okay, this is case number 22 CR 000-479G. You're charged with one count of criminal trespass and damage to property. The offense date is January the 26th, 2022. Pre-trial, do you have anything?
Yes. Last arrest was back in December for obstruction, simple assault, possession of marijuana less than an ounce. That's open in state court, 21 CR 007-962G as in green. He bonded out on the felony charges. I guess this one popped up before he left, when he was getting ready to leave. State, do you have the Texas history?
Yes, I do.
Can you get a judge of history, please?
Yes, Your Honor, he has 11 arrests in Texas. Convictions, he has unlawful carrying of a weapon 2016, possession of a controlled substance more than 28 grams 2016, theft of property between 2,500, 30,000 2017, a criminal trespass and criminal mischief 2018, all convictions out of Texas. He also had an aggravated robbery 2014. That was a juvenile. It was adjudicated. Indecency with a child, indecent exposure 2013. That was a juvenile as well. He pled true. Burglary of habitation, evading arrest, detention, unlawful carry of a weapon, 2013. It was also adjudicated.
Okay,
Your Honor, Mr. Austin is 24 years old. He came from,
hold on.
oh.
I think she wasn't done. Hold on a second. It's okay.
I wasn't there, no. I just lost signal.
Go ahead, please.
I'm back.
Okay,
Okay.
go ahead.
Oh.
Did you?
So that's his criminal history. Oh, and he also has an open assault family violence out of Texas as well.
Okay,
Okay, and I'll go ahead with this report if you would like.
yes.
All right, so on January 26, 2022, officers arrived at the location of 1115 Marsh Trail Circle, that's in Sandy Springs. Upon arrival, they spoke to Miss Latasha Lovejoy, who is on the Zoom. She showed the officers her apartment, which was in disarray. The officers observed a 32-inch flat screen TV that was broken and a dining room chair with the leg broken off, which was made by the defendant. Your Honor, we're asking for a $10,000 cash bond, a stay away from the address, no further contact with Ms. Latasha Love's anger awareness, and no alcohol, drugs, or weapons. Your Honor, this is largely due to the defendant's open cases here in Georgia. He is an open December 27th case, simple assault family violence, which involves the same victim, Ms. Latasha Lovejoy. He was given a no further contact order at that time, Your Honor. In that instance, the victim asked the police to escort her home. After she and the defendant had a prior incident, he followed her home and then tried to attack her while she was in her vehicle with the police there. He also has another simple battery family violence and false imprisonment with the victim less than 14 years of age, 3 counts from 2022. He was given a $16,000 bond. That was on January 30th, 2022, out of Sandy Springs. This also involved the same victim again, Your Honor. However, he posted bond and he was given again a no further contact with the victim. Your Honor, we're very concerned with the victim's safety, intimidation of the witness. He will likely harm her again. And Your Honor, the next time it may be worse. We have talked to the victim. She stated that she and the defendant are no longer married, but they do have children together. And she does not want any contact with him. Again, Your Honor, we're concerned for her safety, given that this defendant has violated the state's conditions numerous times, and he will do it again. So that's why the state's recommending a $10,000 cash bond with the stated conditions.
I'm not something you guys have never talked to me, and I never told you I wanted him to stay away from me. I haven't talked to anyone.
Hold on, Ms. Lovejoy. Ms. Lovejoy, hold on 1 second for me. All right, do this for me. Would you like to address the court?
I'm sorry, Your Honor. That's the wrong victim's information.
Okay.
We have not spoken to her. She may continue though.
All right, so you have not had contact with Ms. Lovejoy in this particular case?
Not in this case, Your Honor.
Okay. All right, thank you. Ms. Lovejoy, would you like to address the court?
Yes, Your Honor. I'm not if you're.
Hold on, I'm going to swear you in before I allow you to talk. So raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am. Yes, Your Honor.
Okay. All right. You can put your hand down. All right. And so what would you like to tell me about this particular case? Not the other cases, but this case that is before the court today that happened on January the 26th.
The items in the home, the TV is Milton's. That is his property. Furthermore, we live together. We share the same apartment, and he also helps take care of my 3 kids, which I kind of need the help financially because I'm not working at the moment. I don't mind him being here, and I'm not in fear of my or anything like that. Like, I'm perfectly fine.
Okay. And so the police was called. Is that correct?
Yes, it was because he wasn't here when the police got here. I walked into my apartment and see my apartment like that, and felt as if it was him because we have been going through whatever we've been going through, and I felt it was him, and that's when I called the police. I walked into my unit and see my unit like that.
Okay. And so are you in fear of Mr. Austin?
No, ma'am, absolutely not. In no way am I afraid of him.
But you do admit you've had several incidents, is that correct?
Yeah, we get into altercations, arguments, and yeah, but I'm not afraid of him or anything, or feel like he's gonna harm me or hurt me or nothing like that. No.
So you don't feel that things are escalating between you but not getting better?
I feel like things are getting better. I mean, every relationship has ups and downs. I feel like we could avoid certain things that we do. We take it too far. I take it too far, vice versa. But I don't feel like he'll like hurt me or anything that sort. Or no, I don't think it's that serious. I feel like we could be mature in certain areas and communicate better, and then we wouldn't have these issues.
And you have 3 children, correct?
Yes, ma'am. All boys, whom Milton take back and forth to school.
Okay, how old are they?
I have a 3-year-old, a 1-year-old, and an 8-year-old.
Okay. And are these Mr. Milton's children or no?
No.
Okay. None of them are his children?
No, ma'am.
Okay. Well, I will say to the both of you, because Mr. Milton is listening as well, you all have 3 children who are watching. And so you have got to learn to get along or not be together, because you've had more than 1 or 2 or 3 incidents, and you must get some help or counseling or find out how to get along or not be together, because your children are little tape recorders who are watching everything that's going on. And so I am very concerned for your safety and for your children's safety, because these things do escalate. We see it here in the courts all the time. And if it doesn't subside or stop, it's not going to get better. It will only get worse. So the state is requesting a $10,000 cash bond, but I want to hear from Ms. Kim before I make my ruling, who is representing Mr. Austin. Is there anything else you would like to tell the court?
Yes, Your Honor. He is 24 years old, and a lot of cases that state and pretrial was mentioning were juvenile. So I don't want that to be considered here at all. Actually, that apartment, the lease is on both Miss Lovejoy and Mr. Austin. So he has a right to stay there. And obviously, Miss Lovejoy wants him back home. And he has been actually disabled, right? He barely got out of that wheelchair not that long ago because of the car accident that he was involved. So he has already gone through hard time, and he's walking with a cane, and it's not the time to be homeless at all.
I was
So-
shot 7 times.
I'm sorry?
I was shot 7 times in a car accident.
Okay, hold on, Mr. Austin. You're not to interrupt. And so your lawyer may not want you to talk. So please let your lawyer finish. All right.
And yeah, that's about it, Your Honor. So we would like to request for a lower bond, since Mr. is not able to work at this point yet, even though he's looking for a job. 10,000 is a little too high. We would like to ask for $2,000, Your Honor.
Your Honor, just to reiterate, he was just arrested January 30th, again, for simple battery family violence with the same victim, false imprisonment with the victims less than 14 years of age, use of a firearm by a convicted felon, and possession of a firearm. We are highly concerned with this defendant's criminal history and the acts that he keeps committing, Your Honor, against the same victim. So that's why we're asking for that bond in those conditions.
Your Honor, may I please have a word?
No, Mr. Austin, I need you to listen to your attorney.
Mr. Austin, you have a right to remain silent. So if you want to talk, may I please have a breakout room? Or can I call you at the courtroom too, and then hear what you want to say?
so I could tell you what I want to say, so you could say it real quick?
No, because that's not how it goes. You're making statements that will probably be against your interest. The state is listening.
Okay,
And,
may I talk for myself, please?
I'm sorry?
May I talk for myself, please? Do I have the right?
That is not how it usually goes, because you may say something totally against your interest that
Okay.
will further help the prosecution of your case, not it won't be anything positive for your case. And my experience tells me that most of the time when the accused wants to speak, they don't know the rules of evidence that would not help their case. It usually hurts their case. So I'm going to caution you to be very, 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 very careful. I don't want to hear about other incidents, only about this one that is before the court today. So if you're going to tell me about some of the other cases and things that they've mentioned, we're not going to discuss the facts of those. So I'm sure Ms. Kim is advising you correctly, and I know that she is, that you need to remain silent. Anything that you say can and will be used against you. So with all of that, is there something that you want to ask Ms. Kim before we can finish? Because I'm going to go ahead and give my ruling.
Ms. Kennedy, about this case that I'm in here for today, like it was said, all the property belongs to me, and it's way too high, and it's understandable. And it was higher than what I just heard. Felonies.
He would like to emphasize that those properties were his properties and the apartment is his place. He has his right to do whatever he wants with his properties. That's it, Your Honor.
Okay.
Your Honor.
Yes.
Your Honor, if I may, I just want to clarify with regard to the bond request, Your Honor, we are requesting a surety bond, Your Honor.
Okay. All right. Well, given the history and what I've heard about the case, I am going to order a $10,000 surety bond. And so that would be $10,000. And I'm going to order that you stay away from 1115 Morris Trail Circle in Sandy Springs. You're not to go back there. I'm going to order no further contact with the victim, Latasha Lovejoy, at this time.
So on this misdemeanor, I've been here since Sunday.
I understand. So you'll need to find somewhere else to go live. And if you go back to that location, you can and will be arrested again. I will allow you to have a one-time police escort if you make bond to return to that location to retrieve your personal items so that you can find somewhere else to stay. And I'm going to order that you have no further contact with the victim, in this case, Ms. Lovejoy. If I don't think, well, the children aren't yours, but if there's any visitation, that it will be facilitated by a third party. You're not to contact her regarding that. There should be some other third party person who will facilitate any potential visitation. No drugs, alcohol, or weapons while on bond. And that is going to be the ruling of the court. Anything else I need to take up, Ms. Guidry or Ms. Kim?
No, Your Honor.
No,
Thank
Your
you
Honor.
very much.
Okay.
Next is position 14, Mr. Meadows.
Okay. Are you Marquavius Meadows? Excuse me, Marquavius Meadows?
Yes, Your Honor.
Okay. And Mrs. Lovejoy, if you want to be dismissed, you can log off since your case is finished. Okay, thank you for your time. All right.
Okay, thank you.
Uh-huh. All right, this is case number 22 CR 000-474A. You're charged with 1 count of carrying a weapon without a valid license and a 2nd count, excuse me, of possession of marijuana less than an ounce with the offense date of February the 1st, 2022. Free trial. Excuse me.
7 total. Last arrest was 7. July 2020, simple battery, family violence, battery, physical harm. 2019 probation violation for burglary out of DeKalb County. 2015 FTA burglary, obstruction, giving false name. 2014 theft by receiving. He was given first offender in 2014 for burglary. Forgery, 4th degree conviction. It looks like he got 2 warrants. GCIC. One is out of Marietta for larceny and one out of Decatur for forgery. That's it.
Okay.
Your Honor, this incident occurred yesterday at 3843 Jonesboro Road. Excuse me, that's the Chevron gas station. Officers were patrolling the area, and they pulled up to the store, and immediately upon pulling up the store, the defendant started to walk away from the store and away from the area in which the police vehicles had parked. Upon exiting their vehicles, police officers smelled the strong odor of raw marijuana when approaching the defendant in this case. And upon encountering the defendant after him attempting to walk away, and the other party he was running away, officers discovered that this defendant had a Taurus 740 40 caliber handgun in his right jacket pocket with 1 round in the chamber and 2 rounds in the magazine. In addition, this defendant had about 17 grams of marijuana. Given the fact that this defendant is a possible flight risk due to the previous FTAs and being currently wanted, the state is requesting a bond in the amount of $3,000 surety. That is $2,000 for the weapon and $1,000 for the marijuana charge. No alcohol, drugs, weapons, or firearms.
All right, Ms. Gant.
All right, thank you, Your Honor. Mr. Markevius Meadows is a 29-year-old gentleman. He has been in the Atlanta area all of his life. He has family ties, including 2 sons, ages 3 and 4, and 1 daughter. Your Honor, he has completed high school. Currently, he is a supervisor at RGIS Inventory. He has been in that has been in that position as supervisor for the past 2 years, and he desperately needs to get back to work to secure his job and also to continue taking care of his children. Your Honor, turning to the allegations, Mr. Markevius Meadows offers a competing version. He states that he denies the allegations. He states that when he witnessed the police, before the police even parked the car, he began to walk away. When the police asked him to stop, he stated that he stopped and cooperated with the police and asked the police, whether or not he had been arrested. Why was he being detained? He states that the police officers gave him no information whatsoever. Your Honor, the warrant states that the marijuana that was ultimately found on Mr. Meadows was in a jar. So we do not believe that there was probable cause for this stop. Furthermore, Mr. Meadows states that he was in the process of purchasing the gun. The gun has not been reported as a stolen weapon. Your Honor, given that the defense has strong grounds for a motion to suppress, Your Honor, I am requesting a signature bond on Mr. Meadows' behalf so that he may deal with those 2 warrants. Furthermore, this is not a crime of violence. The FTA was over 7 years ago. And furthermore, he states that he was unaware of those warrants. And lastly, Your Honor, we are unopposed to any conditions to not have any drugs, alcohol, or weapons. And if your honor determines that he is ineligible for a signature bond, then I'm asking for a bond of no more than $500. And that would be a split bond, carrying $500 for the carrying a weapon and a signature bond for the possession of marijuana. Thank you.
Your Honor, if I may,
Okay.
the state would just like to clarify that the warrant indicates upon exiting the vehicle and approaching this defendant, they smelled the odor of raw marijuana. And at that time, the defendant was approached and the items were found.
Okay.
And your honor, if I may, again, the defense's version of this is that the marijuana was in a jar, and we do not believe that the smell of marijuana would be evident if it's enclosed in a jar.
Okay. All right, I'm going to order a surety bond in the amount of $3,000, $2,000 for the weapon, $1,000 for the possession of marijuana. I'm going to order a stay away from the Chevron. I think it's 3843 Jonesboro Road. I'm going to order no further contact with any of the employees, but I don't think he went inside. So I don't need to do that, did he? I think everything happened in the parking lot. Is that correct?
Yes,
Correct.
Your Honor, that's correct. It was outside in the parking lot.
Outside, okay. So I will not order anything regarding any of the employees, just to stay away from that location. If you get out on bond, Mr. Meadows, you're not to go back there. I'm going to order that there be no drugs, alcohol, or weapons while on bond. Even if you have a license, you're not to possess any weapons, and you are not to have any drugs or alcohol, no drugs unless by prescription, and obviously no marijuana. So that is going to be the ruling of the court. Is there anything else I need to take up?
Nothing further from the state. Thank you, Your Honor.
Nothing further, your honor. Thank you.
Next, we have position 8, Mr. Coakley.
Okay.
Judge, I am showing that the state has submitted a transfer to the DA, and I have it for your signature.
Okay.
That's correct, Your Honor.
All right. So this case will be transferred to the DA's office.
Yes, Your Honor, and it has already been accepted. Just waiting for your signature.
Okay, good.
Is this case going to court today or tomorrow, you know? Anybody?
I don't know. Do
Thought
you-
we was going today, but since it's been transferred, I'd leave it up to Your Honor.
Hold on.
May I ask, ASG Hopkins? He is on.
Bert, are you on?
What is the question?
This case is being transferred, and I think they asked whether it was going to be heard on tomorrow.
I can't
It's
say what
okay.
what they're going to do calendar wise.
They were saying you know everything.
I mean I like the fact that I give off that vibe, but unfortunately I don't know what their calendar looks like tomorrow.
No worries.
Your Honor, given the seriousness of this case and the defendant's serious background, we would ask that it be pushed to tomorrow.
Okay. Yeah,
Yeah.
we'll just reset that, Ms. Bridgewater, for
In
tomorrow.
reference to position 8, Mr. Coakley.
Okay.
Yes.
Why is it being pushed back now?
Your case is being transferred to the DA's office, and they will put it on a calendar. And it's already going to be approved to be transferred, upgraded to a felony. So they will hear it there. Over in the Superior Court. I'm sorry?
What kind of felony?
The charges that you got.
The same charges, but upgraded to a felony, the battery, family violence. And I will tell you, this case is 22 CR 000-481A. You're being charged with 2 counts of battery, family violence. And the solicitor's office has presented the order, and the case will be transferred to the DA's office to be prosecuted as a felony, not as a misdemeanor. So your case is going to be transferred and we are not going to hear it today. Okay? Thank you.
Position 6, Mr. Butler.
You're Kenny Butler. Okay, this is case number 22 CR 0000477G. And you're charged with 1 count of simple battery family violence. The offense date is July 21st, 2020. Do you have anything pretrial?
15 total between Georgia and Tennessee. 2012 FTA, got probation violations from 2010, 2011, 2012, 2019. On probation in Fulton, ag assault, strangulation, and battery. 19 SC 168990 is the case number. Show you all the probation violations, FTA. Tennessee history 2016. Possession of a Schedule 6 controlled substance. That was guilty. 2016. This all the same arrest. Possession of a weapon by convicted felon conviction. Possession of a Schedule 2 controlled substance conviction. So that's it for the Tennessee. And I gave you all the probations and the FTA, so that's all.
Okay. All right, Ms. Guidry.
Yes, Your Honor. So in this case, officers responded to 2524 Martin Luther King Jr. Drive, Southwest Atlanta. They spoke to Jacqueline Knight, common spelling. She stated that she and her husband at the time was in a dispute. The defendant got upset and struck the victim in the leg, slammed her head into the door. He then proceeded to grab her around the neck area and pushed her several times. The two do have children together. They have 2 children. Your Honor, we're asking for a $7,000 surety bond, a stay away from the incident location, no further contact with Jacqueline Knight, 1-day anger awareness, third-party contact with the children, and no alcohol, drugs, or weapons. Your Honor, this is largely due to the defendant's criminal history, given that he has convictions for aggravated assault, battery, aggravated assault, strangulation, all within 2019. And then he also had a aggravated assault out of Tennessee as well, Your Honor. He also has an open fleeing or attempting to elude and fail to maintain improper lane change and reckless driving, which he was arrested for on January 22nd. Your Honor, we're also concerned of the victim's safety, given the instances of what he committed, Your Honor, where he slammed again the victim's head into the door and grabbed the victim around her neck. So that's why we're asking for the $7,000 surety bond with the stated conditions.
Okay.
Yes, Honor. Mr. Butler is 34 years old and he has family ties here in Georgia. He's been here he lived all his life here in Georgia. He has auntie. His father passed away. However, his mother is here. Miss Brenda Robinson is here. And he is actually employed working at the distribution center as a fork operator. And he has been working hard, and he has GED, and he does not have a college degree or anything like that, but he does have 9 children that he's taking care of. They are all minors, 14, 12, 9, 3, 1, 2. There's a lot of responsibility that he has. And right now, Miss Jacqueline Knight is actually, they're almost divorced. So she became ex-wife, and there's no more contact whatsoever. So he does not object to no further contact or stay away from that location. He's totally fine with that. And yet, due to the fact that he has so much responsibilities financially, we would like to request for a $5,000 bond, Your Honor.
All right. I'm gonna order a surety bond in the amount of $7,000. I'm going to order to stay away from the 2524 MLK Junior Drive. No further contact with the victim, Jacqueline Knight. No drugs, alcohol, or weapons while on bond. And I think that is it. Is there anything else I need to take up?
Third party contact with the children.
Oh, third party, contact with the children or third party to help exchange if there's any visitation. And I think that's it.
Yes, that's all, Your Honor.
Okay,
7,000 goodbye.
7,000 good bond, yes.
Thank you.
Thank you, Your Honor.
Okay.
Next, we have position 7, Mr. Cashmore.
I have, looks like I have 2 victims, couple of victims. And then I do I have a private counsel on the line as well? I was just curious as to which cases. But I guess we'll get to them. We'll keep moving. Are you Chance Cashmore? Okay, this is case number 22 CR 000478A. You're charged with 1 count of theft by shoplifting, offense date 12/16/2021. Pre-trial, do you have anything?
36 total. You got 35 adult cycles out of Minnesota. Last arrest was February 2020 for burglary in the 3rd degree, theft by swindle. He went to felony first appearance earlier. He has a $29,000 good bond. What I was told. Hold on. 2018. Suspended license. Another 2020 theft. He got some theft from like 2008, 2009 out of Minnesota. They're all theft by swindle. 2014 theft by taking that was dismissed. He had escape arrest from 2013, escape from custody. Got a lot of traffic stuff in here. That's it.
All right, Ms. Guidry.
Yes, Your Honor. So on December 16th, officers responded to T-Mobile located at 7391 North Point Parkway in Alpharetta. They spoke to Antonio Gonzalez, who's the manager of T-Mobile. He stated that the defendant came into the store to open an account. And while Mr. Gonzalez was completing paperwork, the defendant proceeded to walk around the store, pick up a pair of headphones, put it in his pocket, and then leave the store without paying. The entire incident was caught on camera. We're requesting a $5,000 surety bond, a stay away from 7391 North Point Parkway, and no alcohol, drugs, or weapons. This is largely due to the defendant's criminal history. One, he's a failure to appear, given that all of his criminal history comes out of Minneapolis. He has 2 warrants right now, one for failure to appear and one for larceny theft out of Minneapolis. He has a warrant out of Conyers for failure to appear. So he's a very high flight risk, given that he's a multi-state offender and has failure to appear warrants as of right now. As pretrial stated, he has that burglary 3rd degree open charge out of Minneapolis and a theft 2020 out of Minneapolis. So we're very concerned that he will leave and not come back for court. That's why we're asking for the stated bond.
All
Your
right,
Honor.
Ms. Kim? Yes.
Yes, Mr. Cashmore is 33 years old. He lived almost all his life in Minnesota. That's true. However, he said on and off, he has been here in Georgia about 10 years together. He lives in Atlanta, Georgia now. He has a really good relationship with his grandmother. And since he already has, as pretrial mentioned, he understands that there's a high bond right now, and because of all the unemployment and all the other issues, we request for $1,000 bond, Your Honor.
Oh, and Your Honor, he currently has a $2,000 surety bond. I forgot to state that.
Or state court or superior?
I believe that's state court. Give me 1 second though.
Okay. Because I know pretrial mentioned the other good bond, but he didn't mention that one. That's why I wondered.
I didn't know nothing about the other one.
Oh, okay.
Yeah, I think it's state court. I don't have an order, but it just says he has a $2,000 surety bond in this case already.
What's the charge?
The theft by shoplifting, this one.
Oh, he just got that on the warrant.
Oh, then they must have set that over.
Yeah, they said on the warrant.
Yeah.
Okay, well, I will just continue it with the $2,000 surety bond on this. And remember, Mr. Cashmore, if you make bond, no drugs, alcohol, or weapons while on bond, and a stay away from the T-Mobile store at 7391 North Point Parkway. Okay. That should conclude this case.
I got a question.
Better be very general and brief.
Yes, I just want
You
to,
messed up.
I just want to clarify on my overall bill, how much it is.
Well, they mentioned the $29,000 good bond on your felony. And then there was, and 2,000 on this one. So I don't know what else there may be, but that's all that we can advise you of at the moment.
Well, they didn't say 29,000 to me. They said it was 24. Is there any way to clarify that?
We cannot talk to you about the felonies. You can ask your attorney or talk to her later and she can look into it for you. I don't have that necessarily in front of me. They may be adding, you know, if it's 24 plus 2 is 26. So I'm not for sure where they're getting the 29 versus the 26. But your attorney can maybe look into it and advise you. But I cannot tell you about the felony ones because I don't have that information.
Okay, thank you.
Mhm.
Thank you, Your Honor.
Thank you, Your Honor.
Next, we got position 15, Mr. Moore.
Okay, you Sylvester Moore?
Yes, ma'am.
All right, this is 22 CR 0000469J. You're charged with 1 count of battery. The offense date is September the 2nd, 2021. Pre-trial, do you have anything?
12 total. Last arrest was January 2020 for simple battery, criminal damage to property, 2nd degree. He's on probation for that. They gave him 5 years probation for that, November 2020. Case number 20 SC 175579. 2019 battery, family violence, cruelty in the purse, obstruction. I don't see a disposition for that one. 2019 simple assault, family violence. 2014 DUI conviction. 2012 probation violation. 2009 probation violation. 2009 possession of cocaine conviction. 05 theft of service, no low. And the first offender battery from 05. That's it. And he has a bench warrant too for the battery, family violence, and criminal damage to property. I'm not sure if he went to court for that this morning.
Okay. All right, Ms. Duncan.
Yes, Your Honor, this case took place on, it was September 2nd, 2021 at 599 Mallory Drive. In this case, the victim is Tiffany Jennings. That's common spelling. The facts of this case were that while drinking, the defendant accused the victim, in this case, Tiffany Jennings, of hitting his dog. And I guess the altercation escalated, and Jennings stated to police that Mr. Moore hit her in the face and threw her purse. She said that she returned home and noticed that Mr. Moore had broken her ATM card in half and purchased $100 worth of gas off her card. However, in relation to the incident that resulted in the battery, the defendant in this case punched Ms. Jennings so hard that both her eyes were black and swollen, almost shut. She had advised officers at that time that she would pursue a TPO against Mr. Moore. However, I don't have information as to whether that is in place currently, and her injuries were recorded by officers at the time. Due to the violent nature of this offense, the state is requesting a $5,000 surety bond, no further contact with the victim in this case. We are uncertain as to whether or not that 5995 Mallory Drive is the defendant or the victim's address, and we're unsure if they actually live together, but we ask that he stay away from the victim in anywhere that she may reside. No alcohol, drugs, or weapons, and a one-day anger awareness.
Okay. And what was your recommendation on the bond?
5,000 surety.
Okay. All right, Ms. Gant.
All right, thank you, Your Honor. Mr. Sylvester Moore is 39 years old. He is a long-term Atlanta resident. He has community ties, including his mother, cousins, and siblings. He also has a 10-year-old daughter. Mr. Moore completed high school. He also is working on his plumbing certification. Your Honor, we are opposed to the stay away order as at 5995 Mallory Drive, as that is his family's heir property. Ms. Tiffany Jennings does not live there. At this time, Your Honor, Mr. Moore is unemployed and has been so for the past 6 months. Therefore, he will not be able to make any bond. Turning to the allegations, he denies the allegations. He is alleging self-defense, Your Honor. He states that Ms. Jennings punched him in the face initially, and that he was more so defending himself. We are unopposed to the no further contact order. Mr. Moore desires no contact, and he's anxious to put this matter behind him. We are opposed to the stay away. And again, Your Honor, we are requesting that signature bond if Your Honor determines that he is ineligible, then the lowest bond possible, Your Honor. And also another reason for requesting that signature bond is because of the whole, so that he may be released to deal with that situation. Thank you.
All right. And Ms. Duncan, have you confirmed or not whether that is the defendant's address or the victim's address, the Mallory Drive 5995?
We have not confirmed. That's why we requested in the alternate that he just stay away from wherever she resides, because our victim advocate attempted to make contact with Ms. Jennings, but it was unsuccessful.
Okay. All right, I'm going to issue a $5,000 surety bond. There to be no drugs, alcohol, or weapons while on bond, Mr. Moore. There's no further contact with the victim, Tiffany Jennings. I won't order the stay away, but you're not to go anywhere where Miss Jennings is. I think there's a provision to stay 100, 200 yards away from her. And you're not to contact her via social media, text, phone calls, or any other third parties. So if you see her coming, you need to go the other way. And I think that will be all that I will order for today. Anything else I need to take up from either attorneys?
Nothing further from the state.
Nothing further from the defense, Your Honor.
Okay, great.
Mr. Moore?
Excuse me, yes.
Mr. Moore, I advise you to remain silent, sir, unless you have a question about your bond.
No, it's a question about when he was saying that I had court this morning for the open case.
Yeah,
So I'm trying to find out what was that open case supposed to be.
oh,
The bench, the
He's
bench
referring
warrant
to
was
the
the,
hold. The
yeah, the
hold.
bench warrants. Yeah, it's the battery, family violence, and criminal damage to property. It may go tomorrow morning if he didn't go this morning.
That's the probation that I'm on.
We discussed these things, Mr. Moore. We discussed, we discussed the 3 reasons why you are being held, yeah, sir.
I understand. I understand. Thank you. I understand.
All right,
All
thank
right.
you, sir.
Next, we got position 18, Williams.
All right, are you Taylor Williams?
Ma'am.
This is case number 22 CR 0000483B. You're charged with 1 count of simple battery family violence with the offense date of June 6, 2021. Oh, I'm sorry, did I say 1 count of simple battery family violence and 1 count of simple battery? So it's a total of 2 charges. I'm not sure if I said that correctly. With both the offense date of June 6, 2021. Do you have anything pre-trial?
14 total between Florida and Missouri. As far as Missouri, 2016 forgery, it was dismissed by the state. And a 2018 out-of-state fugitive warrant out of Florida. Last arrest in Georgia was April 2021. Probation violation. Underlying charge, possession of cocaine with the intent to distribute. 2019 trespass, sale of marijuana. Obstruction, hit and run, fleeing an officer. Shows as an arrest only. 2018 probation violation, possession with intent. The 2015 conviction itself. I got sale of Schedule 1 or 2 controlled substance, possession of cocaine with intent, marijuana conviction from 2016. 2015 obstruction, got probation violation from 2013. Possession of a Schedule 1 controlled substance, transaction in drug-related objects. That part was dismissed. 2011 probation violation. 2010 tampering with evidence, theft by receiving, theft by taking, burglary. Everything was a conviction except for the burglary that was dismissed. That's all.
Okay. All right, thank you. Ms. Duncan?
Your Honor, the incidents in relation to this case took place on June 6, 2021 at 2195 DeFore Hills, that's DEFOOR Hills Drive, Road, Northeast Atlanta, Georgia. In this incident, there are 2 victims. The first victim is Tiara Bowden, that's TIARA BOWDN, and Eugenia Bowden, that's EUGINIA Bowden. Tiara is the parent of the same child and other person formerly living in the household with the defendant, and Eugenia Bowden is Tiara Bowden's mother and the grandmother to the child that they share together. So in this instance, the defendant, there was an altercation and the defendant struck Miss Eugenia Bowden in the left side of her face, leaving a visible injury during an altercation. At that time, Miss Eugenia Bowden had known this defendant for a long time, and that's when she let officers know that he is the father of her grandchild. In addition to that, at the same time, there was an altercation between Tiara Bowden and the defendant where the defendant in this case struck Miss Tiara Bowden in the jaw with the closed fist, with the closed hand, and tore her shirt, choked her, and tore her necklaces off. They share a child and they used to live together. However, the victims do not currently wish to prosecute according to what our victim advocate garnered from contacting them. However, given the violent nature of the fact that he hit his children's grandmother in the face and he choked the mother, we are requesting a $6,000 surety bond. That's $3,000 on each charge. And no further contact with the victims in this case. Stay away from the incident location and wherever the other resides if they do not reside together. We're asking for third-party contact for the child, no alcohol, drugs, or weapons, and one-day anger awareness.
Okay. Ms. Gant?
All right, thank you, Your Honor. Mr. Taylor Williams is 31 years old. He is a long-term Atlanta resident. He has family here, including his parents and his children. He is the proud father of 2 twins, age 2, and he shares those children with Ms. Tiara Bowden. Your Honor, we are unopposed to the stay away at this time, Your Honor. That stay away is for an event hall, the 2195 DeFore Hills Road. Mr. Williams has also informed me that he is not opposed to a no further contact order. Your Honor, we see the need for the third party transfer in this case as well. Turning back to Mr. Williams, again, is the proud father of 2 children. He has been in a relationship with Ms. Bowden for 14 years. And although we've heard a lot about my client's history, we did not hear a lot, if anything, and I believe we did not hear a lot, if anything, about any convictions for violence, Your Honor. Mr. Williams is gainfully employed. He has been at King of Atlanta for 2 years as a project manager. That is a family-owned business. However, Mr. Williams does not have the ability to pay a high bond, Your Honor. Therefore, I am requesting a signature bond. And if Your Honor determines that he is ineligible, then a bond of no more than $1,000, and that would be $500 for each simple battery charge. Furthermore, I would like to bring to the court's attention that this incident occurred in June of 2021. He states that he has been in contact with Ms. Bowden without incident. They are actively involved in the care of their children. We did not hear about any FTAs. I believe that is what I heard. I did not hear about any FTAs. And again, he denies the allegations. He states that he's asserting a defense of self-defense. He states that he was at a birthday party. Ms. Bowden became upset with him because he brought his new girlfriend there. He denies striking anyone, including the complaining witnesses, Ms. Bowden and her and the children's grandmother, Ms. Eugenia Bowden. Thank you, Your Honor.
Right, I think I see, is it Tiara Bolden? Do you wish to address the court, ma'am?
Yes, Your Honor.
Okay, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
Okay, put your hand down. What would you like to tell me about this incident before the court today?
The incident did occur. I'm not here for no lies, but I'm not gonna sit up here and just act like he's always been a violent person. Cause again, 14, 15 years is a long time. And out of that time period, that was the first time that he's ever put his hands on me. So he's not a violent person. He's not violent around my kids usually, but I feel like the presence of another woman, I don't really know what it was.
Relevant.
I don't really know what caused the altercation because I wasn't aggressive with him. I wasn't, I didn't put my hands on him, nor was I aggressive towards the female that was with him. I was never aggressive towards anyone on his side of the family. So, and I'm not finna place no blame because I'm not here for that. I'm here to say that I don't want to press no charges on him. In that moment, I did not feel like I could defend myself, nor did I feel like my parents were able to defend themselves. So now like he said, we have had contact. We are cordial. We are both pursuing other things and other dreams and stuff like that. And he hasn't stopped me from pursuing what I want to pursue, and I'm not here to stop him. However, the warrant was out there, and there was nothing that I could do about that warrant. But I'm not gonna sit up here and just act like he's just a terrible person and he violent and outrageous and all that. Like, no, but that one day was a change of character. And that's
Objection, relevance, cause for speculation.
Okay. All right. You can mute yourself back, Ms. Belden. I thank you for your time. And I'm ready to give my ruling. I'm going to give a $6,000 surety bond, $3,000 on each charge. No drugs, alcohol, or weapons while on bond, except for any prescription meds which may be needed. I'm going to order a stay away. And was that 21022, or I may have written it down wrong?
The apparently the incident location is a event hall, so we ask that he stay away from wherever the victims reside.
Okay, all right. I'm going to order no further contact with Tierra Bolden. Mr. Williams, if you make bond or get out on bond, you're not to go anywhere where she is. You're not to go within 200 yards of her, and you are to not contact her by social media, cell, or any contact with Miss Bolden while you're on bond.
May I speak?
Your Honor, we would ask for a third-party contact for the children, and what are the conditions in relation to Miss Eugenia Bolden, who was also a victim?
And I'm sorry, and no further contact with her, with either Tierra Bolden or Eugenia Bolden. Third-party contact when it comes to exchanging for for visitation with the children. You all need to arrange for someone else to do that so that you don't violate your bond by going around Tierra or Eugenia. Okay. And again, no drugs, alcohol, or weapons while on bond. Said anything else, Ms. Duncan or Ms. Gant, we need to take up with the court?
Nothing further. Mr. Williams, I see you have your hand up. Unless you have a question about your bond, sir, I advise you to remain silent.
I just want to know, as far as me being able to see my kids, I talk to her every day.
Yeah, Mr. I don't mean to interrupt you, sir. We have a third-party transfer, sir. You will be able to see your children as we discussed.
Okay, what is it exactly as a third party?
Someone other than Ms. Bowden or Ms. Eugenia or Tierra. It'll need to be another relative or friend who she trusts, and go through that person to see your children.
That's fine.
Okay. All right. That will conclude this matter. Thank you, Ms. Bowden, for your time. You can sign off if you like.
All right, and also, Judge, position 13 is a reset.
Okay.
And we're completed here in courtroom 2.
What happened with number 16
What about 16, Deputy?
and 17?
17 is reset as well, quarantine, I believe.
Quarantine. So 17 will be reset to tomorrow. Deputy, do you know about Mr. Schoenhofer? Position 16?
I'm checking on that right now.
Okay.
Oh, behavioral reset. For position 16.
It's reset as well?
Yes.
Okay, thank you.
All right, thank you,
What
Judge.
about number 12?
Oh, I'm sorry, one more, Deputy.
Yes.
It's 12, reset, MAGA.
Yes, right here, Your
Honor, at the South Annex.
Oh, you're at the south, okay. All right, who do you have there at the South Annex?
I'm sorry, Your Honor.
Yes, who do you have there?
Position, she's position number 12, Miss Magna.
Okay. Okay, that would be Jamila Maga.
Oh.
This is case number 22 CR 00476Y. You're charged with 1 count of terroristic threats. The offense date is August the 9th, 2021. Pretrial, do you have anything?
12 total between Georgia, Indiana, and Illinois.
Okay.
I'll go with Illinois first. 2013 ag assault DV. Damage to property. It just says direct file with court. 2010, it says ordinance. Got a battery, bodily harm, domestic battery that was dismissed from 2008 out of Illinois. Got reckless conduct, 4 counts from 07 out of Illinois. 2010 Indiana disorderly conduct arrest. And as far as Georgia, last arrest was back in June. Simple battery. 2020 ag assault DV. That's the same victim. That's open. 20 CP 191573. That June arrest is a $5,000 pretrial bond. That's it.
Okay. All right, Ms. Duncan.
Yes, Your Honor. As pretrial, as you stated, this incident took place on August the 9th, 2021 at the Southern Grocery Store, which is located at 1083 Westview Drive Northwest. That is the incident location. However, Your Honor, this incident is a part of a longstanding dispute between the defendant and her husband, the victim in this case, Mr. Gillidas Maga Sr. So on this occasion, Miss Maga went to the Southern Grocery Store where her husband works and egged his car and threw other food on his car. And then she sent him a text message of a picture of him in the hospital bed from May of 2020, which is the open case that the pretrial had spoke about for the aggravated assault, 20 CP 191573, where in that case she threw hot oil on the defendant while he was sleeping. So she sent him a picture of himself and caused 2nd and 3rd degree burns. She sent him a picture of himself in the hospital because she was accusing him of cheating. And she said in the text messages, "This you, and you still effing neighbors, you your damn self know that your wife is crazy. So why do you keep playing?" She said, "This is what happened to you last time, and you still went back and fucked a neighbor. I'm going to do it again." All of these images were captured on officers' body cam video. In addition, Ms. Maga has an open case as well, 21 CR 02682Y against the father of her, one of her children at least. And that is the case where she received a $5,000 signature bond. In this current case that is open against the present defendant, her husband, there was a $10,000 surety bond given in that case. Due to this defendant's risk of reoffending and the violent and dangerous nature of the threats made to the defendant, because she has physically harmed him before by burning him with hot oil. And although our victim advocate did speak with the victim in this case, and he said that he didn't want to proceed with charges, we're concerned about this defendant's safety given the egregious nature of the violent acts being done against him. We are currently requesting a $10,000 cash bond. No further contact with the victim in this case. Stay away from the marital home, which she shares with her husband. Third-party contact for the children, if there are any between them biologically. No alcohol, drugs, or weapons, and an 8-week family violence course.
All right, Ms. Gant.
Good evening, good afternoon, Your Honor. This will be my case, Attorney Benchita.
Oh, okay. Okay, he's private counsel.
How you doing today, Your Honor?
I'm fine. How are you?
Doing well, thank you for asking. From my recollection, I believe it is true that Mr. Magna stated that he didn't want to go forward with this matter and stated certain allegations that go against what the state is saying. Just to give you a little bit of information about Miss Magna, she does go through some issues. She is taking medications, and then she does take a shot, which she hasn't gotten since she's been in custody. She's been on disability since she was a child. That's for anxiety, bipolar depression. She takes a shot for pulmonary embolism in her lungs. That's blood clots. So she takes medicine in a shot daily. This is something that she hasn't been getting since she's been in custody. She's 31 years old. She did have 7 children. 5 currently, 15, ages 15, 10, 7, 3, and 2. Unfortunately, 2 of the children, one died last year. I believe that child was 1 month old and died from COVID. And then most recently, another child died in December, and that child was buried just this, I think it was a few days ago on July 28th. What she did for work is what she did for work prior to this was she creates social media content. The address that she lives at is 1055 Ollie, Ollie. That's Circle in Northwest. That's Atlanta, Georgia. That is her house. She recently purchased this house. And with the alleged victim, I believe, to my understanding from the information that I got, was that he's now handicapped due to a situation that was caused not by my client, and she was taking care of him. I understand this incident happened back in August, and since then she was taking care of him, and there's been no issue up until this date. Now we're in February, so she was recently picked up on this incident that occurred in August while she was on her way to take her children to school. Currently, there's no one that can watch the children. Her family resides in Illinois. She has been in the state of Georgia for a few years. Her kids all go to school. So actually, there's currently someone that she recently met, which is essentially a stranger, but they became acquainted, and that's the one that's able to pick up the children. But if it's not your children, that expires rather quickly. I would ask, Your Honor, in this situation for a bit more reasonable bond. My client will not be able to make a $10,000 cash bond. We would ask for a surety bond. I was going to ask for OR, but I understand the alleged charges and history that she has. So I would ask for a $4,000 surety bond in this matter, Your Honor. It appears that the state will not really have a cooperative alleged victim, but this is a matter that my client is adamant she didn't do. But I think it would be better for her to definitely get out and continue her life as well as take care of her children. We agree with the counseling. If there can be no harmful contact between herself and Mr. Magna, we would appreciate that, Your Honor.
Okay. And so you're telling me, sir, that the victim does not live at this Ollie Street with your client?
Currently, that's the information I have, Your Honor. No.
Okay. Okay. All right.
Your Honor, if I may.
And yes, and hold on 1 second. I see that we have the victim on the line as well. Go ahead, Ms. Duncan, and then I'll.
Well, we could take the victim first and then I'll.
The victim? Okay. All right, Mr. Gilda, Mr. Maga, can you unmute yourself?
Yes, Your Honor.
All right. And can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I do.
All right, put your hand down and pronounce your name for me.
Gildas Maga.
Okay. And so are you, what is your relation to the defendant in this case?
This is my spouse. In the future, we both, because I was spending night outside, and then we always have this kind of small arguments, and and also because she has, as her lawyer just said, she has some issue. There was, the experts giving her medicine for because she has a bipolar disorder. So we have some argument in the past, and then we did fix everything and everything in order. She's been helping me because I'm not able to walk. We wasn't fighting everything. Whatever happened on 1083, it was because it was my fault because I left home and I wasn't giving her no help with the kids, and she wasn't happy about it. And I believe that's why she went off. But after that, we fixed everything, and we are in good relationship. And she's helping me because I've been shot last October, and I'm still injured, and I'm in pain. I am not able to take up the case that that we have right now, and it's not easy. So.
Mm-hmm. Okay. How long have you all been together?
We've been together for about 10 years now.
Okay. Okay. And are you in fear of Miss Maga?
I'm sorry, Your Honor?
Are you in fear of her? Are you afraid of her?
No, I'm not afraid of her at all. She's the only one who helped me. Without her, I'm not sure what I'm going to do.
Okay. And so with the terroristic threats, after I hear from Ms. Duncan, I may have some other questions for you. So hang on for a second, okay?
Yes, Your Honor.
All right, go ahead, Ms. Duncan.
Your Honor, the state would just like to reiterate to the defendant's point that she stated that she did not do the offenses alleged. The messages were captured on officer's body-worn camera. And given the violent nature of the offenses between these parties, we will request a bond as stated due to the safety and concern for the victim in this case.
Okay. Okay. Is there anything else before I give my ruling that you would like to say, Mr. Maga?
Yes,
okay.
Yes, Your Honor. Like since I've been shot, I've been going through hardship. So and she stay home mom. She's the only one who take care of my kids. And since I get shot, I haven't been at work, so I have some hardship. And my household, I mean the kids, I don't think I won't be able to afford to pay a bond right now. And in Georgia, I only got her and she only got me. So I'm asking for your help, Your Honor, to to help her out. And we have been good, and nothing going on between us.
If she were to get out, do you think your life would be in jeopardy, or you would
No, Your Honor,
have any
no,
issues? Okay.
no, not at all.
Anything else, Attorney Ben Shada?
Thank you, Ronnie. You said it correctly. I appreciate that.
I was hoping. I apologize if I didn't.
No problem.
Okay.
No, Your Honor, we just stand on asking for a low surety. As the alleged victim in this matter stated, and as I argued, her staying in jail will not only punish her because she does need help. This is a time that she's crying out for help, and I believe it's the position that we would need to help her, Your Honor. So not only would she be in a bad situation, but 6 other people would be, including the alleged victim in this matter. So we would ask for a low surety in this matter, Your Honor.
Objection, Your Honor. We would just like to state that this victim, this defendant, my apologies, is currently on a $10,000 surety bond for burning this victim with hot grease in his sleep because she thought he was cheating on her.
No, these are all, I don't believe that was a conviction. So if I can get back to my argument, Your Honor. Sorry, I lost my place. So we would just ask for a low surety, Your Honor. As I stated before, there will be a lot of people that will be in a worse situation if she stays in custody. I believe no harmful contact is appropriate, as well as counseling. But there are medications that she needs, and there are other people that rely on her, Your Honor. So we stand on our argument. Appreciate you listening to us.
Okay. All right, I'm going to order a surety bond. Now go ahead and mute yourself, Mr. Maga, if you can.
No, thank you, Honor.
Okay, all right. Okay, all right, good. The court, I think that was down at the South Annex that I was getting the feedback from. All right, I'm going to order a $7,000 surety bond. I'm going to order no further violent contact with the victim, Mr. Maga, and I'm not going to order a stay away, but if you make bond, Miss Maga, and you go back, excuse me, to the location, I want to make sure that you're not going to have any more violent contact, or else you'll just bring yourself right back to the jail. So I hope that you get the services and the help, that you need. And that is going to be the ruling of the court. I'm going to also order that there be no drugs, alcohol, or weapons while on bond, except for those that are prescription drugs that have been issued to you by prescription, but no other drugs, alcohol, or weapons, and no further violent contact with the victim, Mr. Maga, okay? So that will be the ruling of the court.
Thank you, Your Honor.
All right, thank you.
Thank you, Your
That
Honor.
concludes my business. May I please be excused?
Yes, you may, thank you.
Have a great one.
Uh-huh. Who else do you have at the South Annex?
That's it from the South Annex. May we be excused, please?
Okay, everything else is reset? Okay. All right, thank you, Deputy, appreciate it.
You're welcome. Have a good evening, everybody.
You too.
Are we ready to go with the calendar now?
I think so, Ms. Bridgewater.
Okay, very good. As a reminder, the reset date for the SAP calendar is February the 15th. Position number 1 is reset to the SAP calendar. There is a $752 purge. Position 2 is reset to the SAP calendar with a total $3,500 good bond. Position 3 is reset to the SAP calendar with a $4,000 total good bond. Position 4 is going to the SAP calendar with a $10,000 good bond. Position 5, SAP calendar with a $5,000 good bond. Position 6, going to the SAP calendar with a $7,000 good bond. Position 7 is going to the SAP calendar with a $2,000 good bond. Position 8 has been transferred to the DA. Position 9 is reset to the SAP calendar with a total $1,000 good bond. Position 10 is going to the SAP calendar with a $5,000 total good bond. Position 11 going to the SAP calendar with a $3,000 total good bond. Position 12 is reset to the SAP calendar with a $7,000 good bond. Position 13 is a medical reset for tomorrow. Position 14 is going to the SAP calendar with a $3,000 total good bond. Position 15 is reset to the SAP calendar with a $5,000 good bond. Position 16 is a medical reset till tomorrow. Position 17 is a reset till tomorrow. And position 18 is going to the SAP calendar with a $6,000 total good bond. Are there any questions, comments, or otherwise?
Could you please restate position 9?
Position 9, yes, ma'am. Position 9 is reset to the SAP calendar with a total $1,000 good bond, and that's $250 on each charge.
And yeah.
Go
Say
ahead,
that
Your Honor.
total again?
I have it as $1,000 good bond. Is that not correct?
I had it as 10,000 with
10.
25.
Okay, with 2,500 on each charge?
Yeah, and it's 4 charges.
Okay, no problem.
Yeah, 4
Not a
charges
problem.
at 2,500.
Got it. Correction made.
Okay.
Thank you.
Are there any others?
Nope, I think that'll do it. All right. See you all next time. Have a good evening.
Have a good evening.
All right. Thanks.
Okay,
Bye-bye.
Judge is getting ready to come to you, okay?
All right. Thank you.
All right, see you
All right.
all later.
Bye-bye.
Bye-bye.